Good afternoon. We would like to warmly welcome you to this seminar, Improving Access to Good afternoon. We welcome you to the webinar Constituent Dialogue between Chile and Canada, the Rights of Indigenous Peoples. This activity is part of the project Improving Access to Civil Justice in Latin America, sponsored by Global Affairs Canada and implemented by Justice Studies Center of the Americas, considering the current political context in Chile being on the verge of initiating a constituent process. We believe that it is necessary to know the different views and perspectives that sister countries have on different topics. In particular, one of the points that has always been in the discussion of the issue of Indigenous peoples, Canada being a reference in the matter. Therefore, the objective of the webinar we are attending today is to generate a space for discussion and dialogue on the situation of Indigenous peoples and their regulation in the Constitution based on the Canadian experience. To this end, we will first have the participation of Michael Gort, Ambassador of Canada in Chile, Jenny Willier-Murphy, President of the Board of Directors of the JSCA, and Jaime Arellano, Executive Director of the JSCA, who will inaugurate today's webinar, providing guidelines for its development. We will then divide the structure of the webinar into two parts. First, the JSCA board member, Benjamin Berger, will introduce the panel entitled The Rights of Indigenous Peoples in the Canadian Constitution, which will feature presentations by Jeffery Hewitt, professor at Osgoode Hall Law School, and Karen Drake, associate dean and professor at Osgoode Hall Law School in Canada. Finally, there will be a roundtable discussion entitled The Rights of Indigenous Peoples in the New Constitution of Chile, with the participation of Verónica Figueroa, Huencho, Hugo Rojas, and Salvador Millaleo. We would like to remind attendees that after each of the presentations, there will be a space to answer questions from the public. And we urge you to send us your questions through the chat of the session or by means of the YouTube channel. We begin with opening remarks by Michael Gort, Ambassador of Canada to Chile. Ambassador to Chile since October 2020, he has had a long career in public service in Canada, having served as Canada's ambassador to Honduras, Nicaragua, and Costa Rica. Ambassador, you have the floor. Thank you, Paulo, and thank you to the JSCA for this invitation. It's a pleasure to be with you here to inaugurate this excellent webinar. It is a pleasure for me to participate in this event, especially for two reasons. First, because it is with the JSCA, they are very close to Canada, and because this is a matter of extreme importance for Chile and for Canada and for the rights of our Indigenous peoples. For over 2 decades, Canada has developed a very close relationship with the JSCA by means of a series of projects of international assistance to strengthen the criminal justice systems in the region. This includes the current project called Improving Access to Justice, Civil Justice in Latin America, which seeks to improve access to a justice that will respect the rights of all people. Canada has been the witness of the important work carried out by the JSCA in the construction of justice systems that are reliable, trustworthy, and of easy access in the region. This work, in turn, has helped protect human rights and has stressed and reinforced democracy, inclusive governance, and the rule of law in the Americas in general. I would like to welcome you to an activity that is even more connected to my work as ambassador. This will be a dialogue between Canada and Chile on the constitutional rights of the Indigenous peoples in our countries. In Chile, this conversation falls right in place with the constitution process that Chile has begun on October last year. As you know, the elections for the Constitutional Convention will take place this Saturday and Sunday. So we are looking forward to the results. Everything points at the fact that the indigenous peoples will be part of the one of the most important items to be discussed with the 17 chairs for representatives of indigenous people. We will be watching attentively and with interest. Canada is firmly committed to a renewed relationship between both our nations with the indigenous peoples, bearing in mind their rights and with great respect. Nevertheless, we are aware that the indigenous peoples in Canada are facing additional barriers for justice, which stresses the importance of moving forward with measures that will help overcome those existing systemic obstacles. We are supporting an indigenous justice system that will assist indigenous peoples in taking on greater responsibility in managing justice within their communities. And the objective is to reflect those indigenous values within the justice system. These community programs are based on the principles of justice and the legal indigenous traditions. They have been designed to reflect the culture and values of the communities they find themselves in. In the second place, we have the commitment of Canada based on a model of civil justice that involves the implementation of Indigenous rights under the Canadian Constitution. In the third place, we're working to transform our justice system, our criminal justice system, in order to reduce the disproportionate level of incarceration and victimization of Indigenous peoples.
These are the public policy measures we're taking as a government, and we accept the fact that these are only the first few steps and that we have a great deal more of work lying ahead. I am sure that the legal experts with us here today, Karen Drake and Jeff Hewitt, will honor their positions at Osgoode Hall and will speak a great deal with regard to what has been done and what is left to do in the future with regard to the Indigenous peoples in Canada. So I am very pleased and excited to be here today to listen to these presentations, and I am sure that moving forward, our Indigenous peoples' rights will be increasingly recognized in both countries. Thank you. Thank you, Ambassador, for your kind remarks. Let us continue now with the remarks from Jaime Arellano, Executive Director of Jsca. He holds a law degree from the Law School of the Pontificia Universidad Católica de Chile, a master's degree in public administration and public policy from American University School of Public Affairs, and a master's in law in litigation and non-adversarial methods from the Inter-American University of Puerto Rico. Jaime, the floor is yours. Thank you very much, Pablo, distinguished ambassador. President of our executive board, Jenny Murphy, Benjamin Berger, Professors Drake and Hewitt, and the other panelists joining us today, and our other individuals who are joining us by way of the YouTube channel. Thank you for joining us this afternoon. This is a very unique opportunity because Chile is currently on the verge of experiencing a historic event this weekend. This is the first time in our Republican history that we will be electing those individuals who will be meeting to draft a fundamental charter for our country moving forward, and the first time they have been democratically elected. Now, this is not the result of political engineering or planification or policy promises, but rather this was the result of what occurred at the end of 2019. There were several events that caused waves in society, and this discussion that we need to hold between in Chile, well, as part of this constituent dialogue, is something that will involve all of us in Chilean society. And one of the major issues that we have faced is trying to find the best way to involve those individuals who are part of our indigenous communities. Canada has a wealth of experience in integrating the indigenous peoples, but something even more valuable, as just recently mentioned by Ambassador Gort, Canada has recognized its progress while also recognizing that there is still more to come and to do. And I think that is something that we have benefited from in Jsca. We have exchanged cultural experiences so that no country has to start from scratch. In fact, what we have done is we have shared the successes and failures of all the countries so that together we can learn from each other to build better models for our justice systems. Now, this constituent dialogue in Chile and this process has brought us closer to another American nation, Canada. And we believe that there is no one better than Canadian professors to speak to us about the past developments. And then we will have a discussion involving Chilean members of academia with regard to commenting on the previous presentations. And so let us try to put ourselves in each other's shoes. We all come from the legal realm, and through law and justice, we are here to build something for people, for our people, for people who we want to be involved in this larger community that we call Chile. So we are here to speak about justice and the indigenous peoples making up our nations. So once again, thank you to Canada, our incredible partner in this process in which we are providing more and more opportunities for access to justice in Latin America. Thank you to our ambassador. Thank you to our councilman Benjamin Berger and the professors who will be joining us as well. And together we will share our experiences so that we can also contribute to this process. And then I would also like to thank Jenny Murphy, the chair of our board. She has taken the time to join us in this opening session. So I'm sure this will be a very interesting event. And I would just like to reiterate that's important for us to put us in the shoes of the other individuals and include them in this process. Thank you. Thank you, Jaime, for your remarks. Now let us continue with a few brief remarks by Jenny William Murphy, the president of the board of directors of Jsca. She is a specialist in rule of law issues, and she has a degree in international relations and Spanish language from the University of Virginia, and she's a Juris Doctor from the American University Washington College of Law. Jenny, the floor is yours. Thank you. First of all, I would like to thank Ambassador Gort for joining us here today at this webinar, and Jaime and the entire team at Jsca for organizing this event. I would also like to thank my colleague, Benjamin Berger, who is on the board with me, as well as the various speakers. Now, as Jaime mentioned, as well as Ambassador Gort, this weekend, Chile will be holding elections during which the society will elect the constituents whose objective will be to draft a new constitution for Chile. the JSCA, with support from Global Affairs Canada, have chosen this topic, that is recognizing the rights of Indigenous peoples, as a topic of conversation, which is part of a series of webinars that we'll be holding. So today, we actually are joined by two Canadian specialists, Karen Drake and Jeff Hewitt from Osgoode Hall, and Benjamin Berger, who is a member of JSCA's Executive Council. We will also have some time to have a discussion with three members of Chile's academia to refer to the rights of Indigenous peoples in the new Constitution of Chile, and the ratification of the Agreement 169 back in the 80s actually recognized the right of justice of Indigenous peoples and recognized their cultural identities as well. This is from the ILO 169 convention, and it states that it's important to apply national legislation, and those peoples who are interested need to make sure that their right to vote is secured. This is critical in a country where, according to the statistics from the 2017 census, more than 2 million individuals state that they belong to an Indigenous community in Chile, and this is 12.8% of the total population. So I hope that this activity will be of interest to our members of the audience from a variety of different countries throughout the continent. And I would like to thank each and every speaker for joining us here today. Thank you. And Jaime, the floor is back to you. Thank you. Thank you, Jenny, for your remarks, and thank you for everyone else proceeding, Jenny. So let us begin this webinar with the first panel entitled The Rights of Indigenous Peoples and the Constitution of Canada. We will begin with some introductory remarks by Benjamin Berger. He's a member of the board of directors of JSCA. He's a professor and research chair in pluralism and public law at Osgoode Hall Law School in Canada. He is also a faculty member of the graduate program in socio-legal studies at York University, and the director of the Osgoode Professional LLM in criminal law and procedure. Benjamin, the floor is yours.
Thank you. And Mr. Ambassador, thank you, Jaime, and my colleague Jenny Murphy, president of the board. It's really a great opportunity to have a chance to participate in and introduce this panel, which to my mind represents an opportunity for a conversation in mutual learning between Canada and Chile, learning about the very basic fabric of our constitutional orders and history, and a conversation facilitated by Jsca. I'm moved as a member of the board, but also as a constitutional law professor with an interest in comparative constitutional analysis, to note that despite very many differences, of course, between our countries, there are what we might call shared genetic features that link our countries very, very closely, features that are closely tied also to the topic of our conversation today. The history of colonialism, overlapping constitutional orders, deep thought about what constitutional justice might look like in that rich history, a rich history filled with both struggle and injustice, but also filled with enormous possibility, enormous opportunity. And as that sharing begins, I want to take a moment just to recognize the land on which I find myself now and the constitutional complexity that comes with that. I'm beaming to you from Toronto, Ontario, working in the field of constitutional law as a latecomer to this territory, to this land, as a settler, and to a long conversation, pre-existing Canadian law and Canadian legal systems about justice and community. Conversation started by the Anishinaabe Nation, the Haudenosaunee Confederacy, the Huron-Wendat, and the Métis. And today, this conversation continues to be carried on by the many indigenous peoples who share and take care of this territory, and in particular by the Mississaugas of the Credit First Nation, the current treaty holders. This, Canada, is a place where constitutionalism began with indigenous legal orders, then friendships, treaties, agreements, all that far predated our current written constitution. And as my colleagues will explain, we live in Canada, in that sense, in the midst of multiple, overlapping, reinforcing, rich constitutional orders. The opportunity before Chile right now at this juncture in its history to imagine what a just constitution looks like in the midst of that complexity is something that excites me as much as no doubt must be daunting to you. So let me say a word just about why I find that moment so exciting. Yes, as a member of the board of Jsca, but also as a Canadian and as a constitutional scholar. And let me do that by sharing how one giant in the history of Canadian constitutional thought and life reflected on moments like the one you're facing. And the person I have in mind is a scholar and an artist named F.R. Scott. He was a leading constitutional thinker prior to our Charter of Rights, which of course was only brought into the Canadian fabric in 1982. Most of our constitutional history has been lived without a Charter of Rights. F.R. Scott was also a famous Canadian poet, a teacher, a lawyer, a poet. And he said the following, and I hope you'll forgive me for quoting at some length. Changing a constitution confronts a society with the most important choices. For in the Constitution will be found the philosophical principles and rules which largely determine the relations of the individual and of cultural groups to one another and to the state. If human rights and harmonious relations between cultures are forms of the beautiful, then the state is a work of art that is never finished. Law thus takes its place in its theory and practice among humanity's highest and most creative activities. And it's that moment that I realized this conversation is leading into in Chile. There's much in that quotation relevant to our conversation this evening. And as we turn to that conversation, let me say just what an enormous pleasure it is for me to draw in two of my most treasured colleagues at Osgoode Hall Law School to speak with you from a place of tremendously deep knowledge about Canadian constitutional law, about Indigenous law, rights, and constitutionalism, Professors Karen Drake and Jeffery Hewitt. Professor Karen Drake is a member of the Wabigoon Lake Ojibwe Nation, a scholar of Indigenous constitutionalism, a scholar of Canadian constitutional law, and one of our current associate deans at Osgoode Hall Law School. She is a sensitive, subtle thinker whose work on understanding Canadian and international law as each affects Indigenous peoples and the interplay between state law and Indigenous law has secured her a place as one of the leading voices thinking through such issues in Canada. Professor Jeffery Hewitt is a nationally and internationally recognized scholar of constitutional law, of human rights, of Indigenous legal orders, and Indigenous governance. A careful, creative constitutional thinker, his work draws on a range of sources, not only legal thought and legal theory, but history, art, and he draws on all of this to illuminate the ways that our collective and legal histories and futures could be imagined. He is mixed descent Cree. He works closely with the Rama First Nation and various Indigenous elders and leaders in supporting and promoting Indigenous legal orders. And so with that, I'm going to recede to the background for now and hand things over to my colleagues, and first to my friend Jeff Hewitt. Jeff, over to you.
Thank you, Ben, and Tanse and Duktamak. Hello, everybody. I'm gonna, like Ben, spend a few minutes just introducing myself to you. I am not in Toronto. I'm in fact in Barrie, so I'm coming to you from Williams Treaties territory, where my family and I live. This is also Anishinaabe territory, a little further north from where Toronto is and where Ben is talking to you about with the Mississaugas, who are part of the Anishinaabe Nation and relatives of the Chippewas, of whose territory we are in. A little bit about me as well. So my father was Cree, but raised in foster care before being adopted. So my family is one of the families in this country who's working to reconnect to specific community and know a little bit about ourselves from both federal government and then finding relatives who were also placed in adoption and raised nearby. So that's a bit about us. I want to also thank Ambassador Gort for his opening comments, and Jaime and Jenny as well, and for Pablo for keeping us moving. I appreciate also being included tonight. I'm really grateful for the introduction from Professor Berger and the ways in which he was able to craft in F.R. Scott. And what I pulled out of the quote was this Constitution thinking and making and teaching and shaping is very much founded in important choices, as you all know. And it's also very much an art, which is something in law sometimes we forget about because we think law can exist on its own, and yet the interpretive nature of it, right, is itself drawing upon lots of our creative resources. So I'm going to speak to you a little bit tonight, probably from a higher or 5,000-foot view, sort of over Canada's constitutional relationships with Indigenous peoples. And then my wonderful colleague, Professor Drake, is going to zoom us in on much more specifics that, that might be helpful for you too. I want to thank too the interpreters for all of their work tonight. I know I've already taken advantage, and I'm grateful for the skills that requires too. So about 20 minutes or so with me at a fairly high level. And then before I begin that though, I want to spend a few words about words. So Indigenous is a general term that I'm using tonight that refers to original peoples of a particular place. And it seemed, at least in Canada, to gain popularity through contributions coming from international law. Aboriginal as a word is stated in Canada's Constitution Act of 1982, and it's also constitutionally defined to mean First Nations, Métis, and Inuit people. I will also be saying Indian tonight from time to time, and that refers to Indigenous peoples who are known as Indian, defined by in the Indian Act, which is federal statute, and more about that in a few minutes. I'll use these words throughout particular context tonight, but otherwise rely on Indigenous to do a lot of the shorthand and heavy lifting of linguistics for me. So where possible, I will also reference specific Indigenous nations by the names they call themselves. So I said Cree man, my father was Cree. Nihio is the name that we say of ourselves, though Cree Nation is big and has different words depending on where the lands are that you are from. So among other things, constitutions serve us as master narratives. They are the stories we tell ourselves about ourselves. There's ways in which society's values are expressed, the ways in which systems give effect to those values, that a master narrative, if you will, are established and structured. So Canada's Constitution is actually a suite of over 30 documents that include the Constitution Acts of 1867, 1982, and the Royal Proclamation of 1763. All of these relate in one way or another to Indigenous peoples. Royal Proclamation of 1763 was a formal beginning between what's now Canada and the British Crown, who had just won a war against the French Crown. Here I want to note for you that while Indigenous peoples were involved on both sides of the war between two European crowns, there was never a declaration of war against, by either crown against Indigenous nations. So the proclamation is recognizing Indigenous nations as nations and sets out that Indigenous lands could only be sold to the crown, not private landholders. There's more to it than that, but that's, for our purposes tonight, what I wanted to draw out. The Royal Proclamation was part of a longer standing process of the doctrine of discovery that we can talk about maybe a little later, and I know Professor Drake will speak to you more about, and which you will all have some experience with too. The Constitution Act of 1867 includes Canada's governance structure. So it establishes the houses of our governments and the courts and the principles for administration of justice. It also creates a division of powers between the federal and provincial governments. And Indigenous peoples are actually listed as a federal responsibility. We are the only people that are so noted. We are listed just after patents and copyright. Section 9124 is a federal authority for, quote, Indians and lands reserved for Indians. So the federal government manages much of its federal responsibilities through the Indian Act, which prior to 1867 was known as the Gradual Civilization Act and was updated in 1867, not long after Confederation. And still today, the Indian Act manages many of those relationships and is often defined as being lifelong. So for those who are defined as Indians under the legislation, they're defined at birth, and it even manages post-death through estate management by the Crown. In 1886, about 19 years after Indigenous people were magically made a federal responsibility, came a decision known as St. Catherine's Milling. And in this decision, the court stated Aboriginal title, if there was such a thing then, was essentially held by the Crown and could be taken away at any time. Provinces could also benefit from what was or were lands of Indigenous peoples. The effect, and why I'm raising the case, has been to provide the Crown with underlying title, which many Indigenous peoples and scholars like Sharon Venn have stated was not included in the treaties negotiated between many, but not all Indigenous peoples and the Crown. In Canada's Constitution Act of 1982, as I move as quickly through time, includes 2 sections specifically addressing Indigenous peoples and a third that is related that I'll briefly explain. Part 1 of the 1982 Constitution Act is also known as the Charter of Rights and Freedoms, and it guarantees the rights of all peoples in Canada subject to only to reasonable limits in a free and democratic society that we structured in Section 1. It also includes Section 25 of the Charter that guarantees no rights protected under the Charter can be used to abrogate or derogate from Aboriginal and treaty rights, including, for example, those rights found in the Royal Proclamation that's referenced in Section 25. What does that mean? Not really sure, to be honest. Section 25 is not widely seen as being a charter right that is generative, and many of the, like the other rights that are included are Kent McNeil and Peter Hogg have written about this and really reference Section 25 as more of a saving provision meant to preserve Aboriginal and treaty rights as opposed to create them. And there's virtually no judicial considerations of Section 25 because Indigenous peoples haven't been particularly active in bringing challenges under the Charter, though that's beginning to change in the past few years. And I had to predict, or you asked me to, I think we're going to see more Indigenous engagement in defining Charter by bringing challenges. But part of the Charter of Rights, the Equality Rights, that other section that doesn't specifically name Indigenous peoples but is involved, is part of our equality section, Section 15.2. Specifically, this allows for a government to create a program or service or policy decision to ameliorate the conditions of certain individuals or disadvantaged groups. So the court found about 15.2 as it begins its interpretive work in a decision known as CAP, that a program aimed at allowing the granting of communal fishing licenses to Aboriginal peoples, and that granted Aboriginal fishers access to commercial fisheries a few days in advance of the other commercial fishing operations, was allowable under the Charter, because in section 15.2, it had a remedial objective in favor of Aboriginal peoples. I raise this to say it's not really an accident that this decision comes out of section 15.2 as opposed to section 25, which isn't generative, but section 15 on the equality rights is. Part 2 of our Constitution Act of 1982, which is outside the Charter but in the Constitution, is section 35, which states Aboriginal and treaty rights are hereby recognized and affirmed. Section 35 sub 2 defines Aboriginal peoples as being a First Nation, Métis, and Inuit. And since 1990, with the Sparrow decision, there's been about more than 90 cases from the Supreme Court filling in what Canada means by Section 35 and interpreting Aboriginal and treaty rights hereby recognized and affirmed. And through this suite of decisions, there continues to define much of the legal relationship between Canada and Indigenous people. The court throughout continues to assume Crown sovereignty that I was raising a few moments ago over Indigenous lands and peoples. And while treaties are to be liberally interpreted, as the court has set out, in favor of Indigenous peoples, the decisions that are rendered under Section 35 or out of Section 35 do not always read as liberal in favor of Indigenous peoples. Some of the decisions and subsequent government responses that maybe the ambassador was leaning into earlier because this is an ongoing national project. Some of those decisions from the court on led to a lobster fishery crisis in our country last summer and fall with Mi'kmaq people, and that stems from an 18th century treaty and a pair of 20th century decisions from Section 35 known as Marshall I and Marshall II. There's been other decisions that have held that so long as the Crown is deriving benefit from treaty lands, regardless of how long the treaties were signed back, how long ago, the Crown obligations continue as long as the Crown is deriving benefit from treaty, which we can safely say in 2021 in Canada, the Crown continues to in terms of driving benefit from Indigenous lands and resources. There are also decisions such as Haida that establish a duty of the Crown to consult and accommodate Indigenous peoples in relation to Crown decisions. Before Section 35 cases became about, in a decision known as Calder in the 1970s, it led us to post-Section 35, or now current Section 35 cases like Silkuteen that reaffirm and establish Aboriginal title, help us define further the ongoing question with respect to, is there Aboriginal title? Answer yes. What does that then entail? The court begins to define this conversation in Silkuteen or further advances it. We haven't quite figured out the contours of all of it yet. Other decisions like Chippewas of the Thames do not require Indigenous people to be consulted on pipelines and changes of pipeline content and flow. Some cases that my colleague Professor Drake will talk more about, such as Vanderpeet, establish a real framework to interpret and engage with treaties and Aboriginal rights that favor a master narrative of Canada, underlying assumption of title lies with the Crown. That master narrative, when it was first developed in 1867's Constitution Act and in 1982, didn't, to the extent that it should have, also include part of the worldview of Indigenous peoples. Well-known Anishinaabe scholar John Burroughs has written much about the constitutional relationships in Canada and ways to consider writing it. What I really hope to set out here is to be mindful of assumptions when considering aspects of constitutional drafting. There really cannot be justice in a constitution if the document itself reflects a master narrative that renders Indigenous peoples as supporting actors. It cannot be justice if a constitution has the appearance of including Indigenous peoples, but is really structured about maintaining an underlying status quo. So master narratives really matter. They tell us about ourselves and tell others how we want them to relate to us, much like I did for you in the introduction of who I am and how I came to be here and who my family is, at least a little bit about them. Constitutions, the master narratives, become the stories that we want to also tell. So generating a constitution is to write a master narrative, and whatever that will be is going to be up to you. And creating that story, that constitution, is about worldviews. Canada's worldview comes from, formally, the time of the Royal Proclamation that begins to formalize the story derived from and subsequently becomes Canada's own, but starting in the United Kingdom. And it's evolved in a particularly unique trajectory that can only be Canadian. There have long been, as Ben spoke about in the introduction, Indigenous worldviews, laws, systems of governance in what's now known as Canada, even before there was a Canada. And those peoples and worldviews continue to thrive inside what's now Canada today. Indigenous worldviews have yet to fundamentally be written into Canada's constitution, and thereby really shape the country's systems and institutions to include Indigenous worldviews. Blackfoot scholar Leroy Littlebear has written about this and tells that worldviews can coexist and are vital to engage with because worldviews influence social, political, legal, cultural structures and systems. An example of this is how I've been taught in the Hio worldview that we're here to form relationships to all living things. Fundamentally, we develop kinship relationships, and that's foundational to the development of Nihil law. It impacts our structure of laws that focus on setting out maintaining good relations, miopamatsuin, living in a good Cree way, versus the management of relations among strangers. Sharon Venn, Sylvia McAdam, and many other Indigenous scholars have written about this. Indigenous peoples in Chile will also have worldviews that matter deeply and have been long developed over millennia. Cree scholar Val Napoleon, in her article, Thinking About Indigenous Legal Orders, offers us some distinguishment between legal orders and legal systems. Orders, legal orders are the big ideas and the values, the sorts that one might find in a constitution, for example. But legal systems are the institutions, means, processes in which legal orders are practiced, upheld, interpreted, structured through courts and tribunals, commissions, boards, etc. This shapes, the legal order shapes the constitutional ideas and forms the structure. It's also ripe with potential for much to be lost in translation from Indigenous legal orders within common law legal systems. And something risks being stripped away without care and attention to the differences between legal orders and legal systems when we're contemplating constitutional drafting. Though already adopted in Chile long ago, Canada continues to also sort through all of this as an ongoing relationship. And currently we have a federal bill, C-15, that seeks to implement the United Nations Declarations on the Rights of Indigenous Peoples. And this is an important contribution, that the bill seeks to ensure the United Nations Declaration is compliant with, for example, Section 35 of the Constitution, is still something to be sorted out and not without critique. Though it misses also maybe a key point that the inclusion of the declaration in Canadian law will matter. And what many of us hope, generate ways, more ways in which to engage with and include Indigenous worldviews in the master narrative. So I hope here to have offered some texture in considering constitutional design in relation to Indigenous peoples, and at least at a surface level, glide across some of the with more nuance to obviously be discussed in another day, some of Canada's constitutional experience with respect to developing relations with Indigenous peoples and how Indigenous peoples may find their relationship to Canada's constitution unfold. The main ideas I'm hoping to leave you with today are in relation to Indigenous peoples and constitutional imaginings. As Ben pointed out at the beginning, this is constitutional drafting is much about a legal imagination and so much more. Also a social and political and cultural imaginations. And there's no necessary limit in design. Be mindful of bias and assumptions, including what might be there and what is not there. Who is present in the conversations and design, and who is not. Resist assumptions that a worldview is also the worldview, when I hope to have expressed that that is not true. There are a multiplicity of worldviews that help enrich constitutional development and design. And it all starts with a story. What is the narrative you want to tell? How does the narrative include and reflect Indigenous worldviews? How will Indigenous legal orders be reflected richly, not only in the narrative, but in the systems designed to uphold and interpret that narrative? I'm going to, coming up on 20 minutes minus 45 seconds, hand things over to my colleague, Karen Drake. And I say hi, and thank you very much for being here and listening when I know you have no doubt many calls on your time right now. So I'm grateful to be here and look forward to speaking with you more. Karen.
Wonderful. Thank you so much, Professor Hewitt. That was an outstanding synopsis and discussion of Canadian constitutional law as it impacts Indigenous peoples. Well, good evening, everyone. I'm speaking to you from the city of Toronto in Canada, where I'm a visitor within Anishinaabe territory. More specifically, I'm in the territory of the Mississaugas of the Credit First Nation. And as Professor Berger mentioned, I'm a member of the Wabigoon Lake Ojibwe Nation. Our territory is in Northwestern Ontario, and we are signatories to Treaty 3. I'm absolutely delighted and tremendously grateful for this opportunity to engage with you. And I want to thank Professor Berger and the JSCA for this invitation. My goal today is to provide some lessons learned in Canada about our experience of providing constitutional protection to Indigenous rights. As my colleague Professor Hewitt explained, our key constitutional provision is Section 35 of the Constitution Act of 1982. The text of Sub 1 of Section 35 states, quote, "The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed," end quote. That's it. That's all it says. Now, granted, there are 3 more subsections to Section 35, but they don't specify the content of Section 35 rights. And so, as Professor Hewitt explained, it has fallen to Canada's courts to define the content of Aboriginal rights. And this has been an ongoing project for the past almost 40 years. Now, from one perspective, this project has been a success. Section 35 has given Indigenous peoples some court victories. And as a result, we have greater ability to engage in our cultural practices, to make some use of our territories, and to exercise some of our rights protected by our treaties. Now, on this view, Section 35 is making progress towards fulfilling its promise of achieving reconciliation between Indigenous peoples and the Canadian state. But from another perspective, the story of Section 35 has been one of disappointment and distortions. Canada's leading Indigenous law scholars, including John Burroughs and Val Napoleon, have criticized the Section 35 jurisprudence for failing to protect Indigenous laws. In other words, they've criticized the case law under Section 35 for failing to protect the lawmaking authority of Indigenous peoples, or in other words, the jurisdiction of Indigenous peoples. For example, scholars have argued that the legal tests developed by the courts protect frozen rights instead of the self-determination of Indigenous peoples. Now, how can we understand the divergence between these two perspectives? Well, I submit to you that the first perspective is the perspective of liberalism, while the second that I described is the perspective of Indigenous constitutionalism. Now, I'm using the term constitutionalism here, not in the narrow sense of a political system that places limits on governmental powers. Instead, I'm using the term constitutionalism in the broader sense articulated by John Burroughs and Aaron Mills, who use this term to designate a framework for how a people constitutes itself as a political community. My thesis builds on Professor Hewitt's presentation and his exhortation to account for the differences in Indigenous and non-Indigenous worldviews. So I argue in this presentation that the reason Section 35 has failed to protect Indigenous jurisdiction is because the Section 35 case law filters Indigenous jurisdiction through the lens of liberalism. And the result is a distortion and an evisceration of Indigenous laws. Now, Aaron Mills describes this phenomenon as constitutional capture, and Gordon Christie refers to it as the liberal snare. And Professor Christie argues that the Supreme Court of Canada's Section 35 jurisprudence is simply one immense liberal snare. In other words, on this view, Section 35 has not achieved reconciliation, and it represents not the rejection of colonialism, but rather the perfection of colonialism. Now, to understand this, Professor Mills provides us with a tree model of legality to explain how constitutional capture works. The explanatory force of this model, the tree model of legality, applies equally to Indigenous and to non-Indigenous legal orders. So you can picture for yourself two trees standing side by side. One of these trees represents an Indigenous legal order, and the other tree represents a liberal legal order. The roots of each tree represent that society's worldview, including its ontology, or in other words, its view of what there is in the world, its epistemology, or in other words, its view of how we come to have knowledge and what is the nature of truth, and its cosmology, or in other words, the story that the society tells itself of creation. Now that's the roots. Now, moving up from the roots to the trunk. The trunk represents a society's constitutional order, or Professor Hewitt used the term legal order, or in other words, its practice of governance that enables collective action. Now, moving up from the trunk to the branches. The branches represent the legal traditions of the society. And I mean legal traditions in the sense of the processes that the society uses to generate, interpret, modify, and destroy its laws. Finally, we move from the branches to the leaves. And the leaves represent the society's laws. Now, the key to this model is that each level, the roots, the trunk, the branches, empowers and constrains the one above it. But each level does not definitively determine the one above it. So, for example, the roots of a particular kind of tree, so for instance, in Canada, we have birch trees, which are very popular and common. So imagine the roots of a birch tree. Well, those roots can only produce a birch trunk. They'll never produce the trunk of a pine tree. And yet there's much variation among the trunks of different birch trees. And so the tree model of legality cautions against attempts to filter Indigenous laws through a liberal constitutional order. In other words, you can't take birch leaves from a birch tree and try to paste them onto a pine tree, right? They won't grow. Likewise, attempts to implement Indigenous laws within the political and legal architecture of a liberal state result in incoherence and structural violence to Indigenous law. Or in other words, an attempt to graft the leaves of Indigenous law onto the tree of liberalism results in constitutional capture, or in other words, the liberal snare. Now, I find that Professor Mills's tree model is an especially powerful tool for combating the assumption that liberalism is neutral. Now, this notion that liberalism is neutral is at the heart of the assumption that Indigenous laws could potentially function effectively within a liberal order. Now, before I explain this further, I should pause and acknowledge that there is no one single version of liberalism. Thus far, I've been discussing liberalism writ large in general. However, I want to acknowledge that there are many variations and permutations of liberalism as both a political theory and insofar as it is instantiated within any given state. Now, that being said, I follow Will Kymlicka in holding the view that all forms of liberalism, regardless of their various differences, have at least one feature in common. In other words, in order for a theory to be a liberal theory, it must be committed to the following principle, namely, that every individual is entitled to determine for themselves their own conception of the good life, and to structure their life in accordance with that conception, provided, of course, that their conception of the good life does not cause harm to others. Now, this is where the assumption that liberalism is neutral comes into play. The assumption is that by not specifying any particular content of the good life, liberalism can allow for a wide variety of normative content, including, presumably, the operation of Indigenous laws. But liberalism is not neutral. Liberalism has normative commitments. In other words, liberalism has roots and a trunk, just like any other constitutional order. Now, the principle that I just mentioned, that each individual is entitled to determine their own conception of the good life, is in fact one of these normative commitments. This principle, in turn, is grounded in a commitment to the primacy of the individual. In other words, within liberalism, the individual is the rights bearer. Now, the rationale for this premise that the individual is the rights bearer, or in other words, the entity that holds rights, the rationale for this is the inherent dignity of the human person. And this commitment to the inherent dignity of the human person, in turn, grounds the principle that rights are universal. Now, what this means, this principle that rights are universal, within liberalism, this merely means that each and every individual is equally entitled to exercise the rights protected by liberalism because of that individual's inherent dignity as a human person. However, this principle that rights are universal is sometimes assumed to mean more than this. It's sometimes assumed to mean that the discourse of rights, in other words, the language of rights, can be employed within any constitutional order. In other words, it's sometimes assumed that the language or discourse of rights itself is universal. But this is incorrect. The discourse of rights flows from the normative commitments of liberalism. Or in other words, the discourse of rights is grounded in the roots and the trunk of liberalism. Now, for example, liberalism posits a dichotomy between, on the one hand, individuals who exercise rights, and on the other hand, the state, which exercises jurisdiction. In other words, individuals do not exercise jurisdiction or lawmaking authority. Only the state exercises jurisdiction in the form of lawmaking power or authority. The possibility of a concept that straddles the divide between rights on the one hand and jurisdiction on the other sits uneasily within liberalism. And equally, the possibility of a concept that straddles the divide between the individual on the one hand and the state on the other also sits uneasily within liberalism. Now, a liberal theorist might respond that my description of this dichotomy is too stark. They might argue that it is possible to find a middle ground between rights on the one hand and jurisdiction on the other in the form of a right to exercise jurisdiction, or in other words, what is commonly referred to as a right of self-government. And they might also argue that there is a middle ground between the individual on the one hand and the state on the other in the form of a collective or a group, which can hold rights. However, collective rights, such as a right of self-government, are a conundrum for liberal theorists. Collective rights have not fully penetrated the armor of liberalism. While some liberal theorists have attempted to articulate a liberal justification for collective rights, such as the right of self-government, the result has fallen far short of protecting Indigenous jurisdictional authority. For example, scholars have argued that Will Kymlicka's liberal defense of group differentiated rights for Indigenous peoples protects mere cultural rights, but not the jurisdiction or the sovereignty of Indigenous peoples. This is because the notion that a non-state actor could exercise truly jurisdictional and lawmaking powers defies the logic and the normative commitments underpinning liberalism, such as the primacy of the individual. In other words, those of us advocating for the right of self-government for Indigenous peoples are caught inside this liberal snare. And we can see this liberal snare being replicated in the Section 35 jurisprudence. And in particular, I have in mind the Supreme Court of Canada's decision in the Vanderpeet case. Now, in this decision, the Supreme Court of Canada characterizes Section 35 Aboriginal rights as illiberal and uses the supposed illiberal nature of Aboriginal rights as a reason to limit them by characterizing them very narrowly and with a high degree of specificity. Now, more specifically, what the court says in Vanderpeet is, quote, "In the liberal Enlightenment view, rights are held by all people in society because each person is entitled to dignity and respect. Rights are general and universal. They are the way in which the inherent dignity of each individual in society is respected," end quote. The court then goes on to say, Aboriginal rights cannot, however, be defined on the basis of liberalism. Okay, why not? Well, the court explains that the difference with Aboriginal rights is that they are held only by Aboriginal peoples and not by all members of society equally. In other words, the Supreme Court views Aboriginal rights as illiberal insofar as they violate the principle of equality. Aboriginal rights do not satisfy the liberal requirement of being universal. Not all individuals within Canada are equally entitled to exercise Aboriginal rights. Only a subset of the Canadian population is entitled to exercise Aboriginal rights, Aboriginal peoples. Now, on this analysis, Aboriginal rights appear to be an extra social good or a special benefit that only Aboriginal peoples receive, and they appear to be something above and beyond what all other Canadians are entitled to. Now, because of the perceived illiberal nature of Aboriginal rights, the majority in Vanderpeet held that these rights must be defined with specificity. In other words, they must be defined narrowly and constrained. And the way that the court did this was twofold. First, they imposed a pre-contact assessment date when it comes to establishing Aboriginal rights. And second, they imposed a test for assessing whether any given claim will constitute an Aboriginal right. And this test is as follows. It says that in order for a claimed right to be a Section 35 Aboriginal right, the activity in question must be a practice, custom, or tradition that was integral to the distinctive culture of the Aboriginal society before European contact. In other words, before Europeans arrived in the territory of the Indigenous people concerned. Now, this is a very narrowing test. It's a very high threshold. The result is that very few claims are protected as Aboriginal rights. And we can see an example of this illustrated most clearly in the Supreme Court's decision in a case called Pimaginawan. Now, in this case, in Pimaginawan, there were two First Nations who were charged with running bingo games on their reserve without having the required governmental permits. So they were holding bingo games, they were playing bingo, but they didn't have the licenses or permits required to do so by the provincial or federal governments. Now, the defense of these First Nations was that they have a right to organize and run these bingo games on their own reserve, pursuant to their right of self-government. However, the Supreme Court of Canada refused to allow these two First Nations to characterize their claims as claims to self-government. Instead, the Supreme Court held that a claimed right of self-government is too broad. The court said that that claim is articulated at a level of excessive generality. Instead, the claimed right must be articulated at the level of specificity that's required by the Vanderpeet test. In other words, it must be articulated with a high degree of specificity. And so instead of examining whether these two First Nations were entitled to exercise self-government, instead, the court characterized their claimed right as the right to participate in and regulate high-stakes gambling. And so in this way, the specificity requirement from Vanderpeet produces something closer to cultural rights. If the First Nations in Pimaginawan had succeeded, which they didn't, the most they could have gotten was the right to participate in and regulate gambling, but not the right of self-government in general. And so the Vanderpeet test precludes the possibility of comprehensive Indigenous jurisdictional authority. In other words, we're still stuck inside the liberal snare. Now, we can examine this assumption on the part of the Supreme Court of Canada that Indigenous rights are illiberal. Are they illiberal? Is it really the case that Indigenous rights are something special, something extra, over and above the rights that are exercised by everyone else? Now, in the Canadian context, at least, the answer is no. Section 35 rights, Aboriginal rights, are not extra rights. They're not a special entitlement that's given only to one segment of the Canadian population. To understand how this is the case, it's necessary to first understand the basis of Canada's claim to sovereignty over the territory that is now known as Canada. Canada's justification for its claim of sovereignty is the doctrine of discovery. And this is affirmed by the Supreme Court of Canada in a number of modern decisions, including Guerin, Calder, and Sparrow, which affirm a US Supreme Court decision called Johnson and McIntosh, which explicitly adopts the doctrine of discovery. Okay, so what is the doctrine of discovery? Well, according to this legal doctrine, European nations were entitled to assert sovereignty over the territory of Indigenous peoples because of the supposed inferiority of Indigenous peoples. And on the version of the doctrine of discovery that applies in Canada, what Indigenous peoples were left with when Europeans arrived and asserted sovereignty and thereby claimed sovereignty over all of their territory, what Indigenous peoples were left with was not nothing. So although we lost our sovereignty merely by virtue of Europeans arriving here and asserting the doctrine of discovery and asserting sovereignty over us, we lost our sovereignty, but we were left with something. We were left with tenuous rights to occupy our land and to use it for limited purposes. And these limited rights of use and occupation are what have developed into the doctrine of Aboriginal rights. In other words, according to the doctrine of discovery, Aboriginal rights are the leftovers assigned to Indigenous peoples after the doctrine of discovery erases Indigenous sovereignty and Indigenous jurisdiction by presuming the inferiority of Indigenous peoples. And so Aboriginal rights or Indigenous rights are not something extra afforded to Indigenous peoples over and above what everyone else is entitled to. On the contrary, it's Aboriginal peoples who have suffered from unequal treatment through the doctrine of discovery. And given that equality is a foundational tenet of liberalism, it's actually the doctrine of discovery which is illiberal. And so if we understand Indigenous rights instead as protecting Indigenous sovereignty and Indigenous jurisdiction, then Indigenous rights simply protect what all other nations enjoy and what was denied to us through the doctrine of discovery. Now, in conclusion, I have two recommendations to offer any state which is grounded in liberalism, but also wants to constitutionalize protections for Indigenous peoples. My first recommendation is don't leave the details to the judiciary. Specify the content of what is being protected upfront in the Constitution. My second recommendation is don't use the normative architecture of liberalism. In particular, I suggest that it's preferable not to use the language of rights. Banish the notion of Indigenous rights from your vocabulary. Instead, the text can explicitly refer to and protect the jurisdiction of Indigenous peoples. Right? So the focus, the protection can be on Indigenous jurisdiction as opposed to Indigenous rights. And Indigenous jurisdiction includes the lawmaking authority of Indigenous peoples and our laws. The text should also state that this jurisdiction is inherent, which means that this jurisdiction inheres in Indigenous peoples' constitutional orders and need not pass through any test formulated by the judiciary in order to be operative. In other words, this jurisdiction need not conform to any test such as the Vanderpeet test in order to be effective. That's what it means for it to be inherent. So these are some key ways that constitutional protection of Indigenous jurisdiction can avoid constitutional capture and avoid the liberal snare. Thank you, and miigwech.
Muchas gracias a ambos expositores por su completa
Thank you to both speakers. We have a question to continue with the presentations. It's aimed at both speakers. The question is as follows. What are the keys, in your opinion, that should be taken into account by the drafters of the Constitution to recognize Aboriginal people, because there has been no reference made to them? I would like to offer the floor to our speakers, Jeffery and Karen.
You go ahead, Professor Hewitt.
Professor Hewitt.
Okay, this is a great question, and thank you for raising it. I think the answer is fairly straightforward in that Indigenous peoples themselves are the key. They have the answers. I think both Professor Drake and I were indicating that throughout what we were saying. And for me, part of that is, don't make assumptions that we know something until we talk to the people who actually have it. So rather than, and I think Professor Drake did a great job too at indicating this in much nicer language than I'm about to, which is to say, Indigenous peoples aren't actually a problem to be solved. They are actually the solutions. And so in terms of a key, I would say speak to and include Indigenous people from the outset, so that assumptions don't get made in terms of how narratives get built as you proceed, but rather are co-developed. So inclusion at the outset in both formal and I think informal ways, but that have fundamental influence on how constitutional narratives get structured from the outset, for me is I think the way to start.
I would echo all of that. So I gave some fairly specific recommendations, but of course they're grounded in our particular experience, as I mentioned, over the past 40 years. And I talked about Indigenous constitutionalism as a way of, I guess, making the material accessible. But I really can't speak to the constitutionalism of all Indigenous peoples. I don't think there is such a thing. I have some very small understanding of the constitutionalism of my nation, the Anishinaabe Nation, but it's still very small. So I would absolutely echo Professor Hewitt in saying that it's up to Indigenous peoples to guide the discussion about what is going to be best to protect what they're seeking.
Can I also just add a little bit to that too? And it comes out of the reconciliation project that's happening in Canada right now with Indigenous peoples, that even the way reconciliation can get framed sometimes is presumptive. It assumes a shared architecture, a shared meaning of language and approaches that may not necessarily be the case. And so I would say even before there's any tables developed or the structure of how constitutional talks will happen, that actually includes Indigenous peoples in determining structure of approaches. And before anything is even crafted and processes are set up. So that the process itself is also multi-juridical, in that it includes the ways of being and thinking and laws of and orders of Indigenous peoples, who should also not be seen as monolithic. Right? That all Indigenous peoples will have different ways of being, and there isn't a singular voice, and nor should, in my view, Indigenous peoples be asked to speak with a unified approach. I mean, if the rest of the country can't do it, I'm talking about Canada, Indigenous people shouldn't have to be compelled to a standard that nobody else does either. So inclusivity from the get-go, including before processes and procedures are structured.
Muchas gracias por su respuesta. Tenemos más preguntas.
Thank you for that. We have another question for both of you. According to the Canadian experience, what are the obstacles that the Indigenous peoples face with regard to access to justice in the event that their rights are trampled? You can answer in the same order if you'd like.
Professor Drake, do you want to go first this time? No? Okay. A lot would be my short answer to that in terms of obstacles. I think Professor Drake, and she can illuminate more on this, talked a great deal about the structures that have been put in place that become obstacles, including the framework itself can sometimes trip things up. I think in terms of access to justice as well, and some of the concepts I was talking about, even the system And having to engage in the system and the language of the system can be an obstacle because it's making assumptions about who's arriving, and it's predeterminative about the ways in which law and questions of law will be heard. So some major systemic obstacles, to be sure, and those are just a couple of examples of many. With that, I'll hand it over to Professor Drake.
Yeah, so I mean, this could be an entire paper or dissertation in of itself. It's an excellent question. I mean, one of the key barriers to access to justice for Indigenous peoples in Canada stems from the Van der Peet test that I mentioned. And I mentioned that that test establishes an assessment date of prior to European contact. What that means is that if Indigenous peoples want to be successful in their claim for an Aboriginal right, they must provide evidence from prior to European contact that the activity that they are claiming as a right was integral to their distinctive culture prior to European contact. This can be a tremendous hurdle. So for some Indigenous peoples in Canada, European contact was as much as 500 years ago. In other words, we need evidence from 500 years ago, right? So in our system, we have a limitation period of 2 years or a global limitation period of 15 years. And the rationale for that is because it's thought to be too onerous for litigants to preserve evidence for longer than that. And yet Indigenous peoples are supposed to have evidence going back 500 years in order to substantiate their claims. Some other key access to justice barriers are time and money. So an Aboriginal rights claim, especially an Aboriginal titles claim, can take decades in order to go through the negotiation process and to get to court and then to go through the various stages of court. And money, it can take millions of dollars to get through this process. It can require experts in various different fields of ethnography, history, anthropology, and so on.
Yeah, can I just pick up a bit on that too, is that those experts themselves have to be qualified in rules and systems that are Western in terms of formalism, formal education. And so Indigenous peoples who are experts in the very nature of, Indigenous anthropology and Indigenous science, all of which we have, are not often qualified or deemed as credible, right? Because the moment that you bring in experts, the system requires a weighting of credibility among other factors, not deemed as credible as the folks who are not Indigenous but have been formally trained at particular schools by and have certain levels of experience. So that becomes another barrier. The other thing I would pick up on too that Professor Drake talked about with Van der Peet and the Sparrow decision is that one of the biggest barriers for Indigenous peoples is the idea of unilateral extinguishment and justification by the Crown of infringement. So the way that the system works for Section 35 is that if an Indigenous claimant can prove the existence of the right, having dealt with all of the evidentiary burdens and barriers that Professor Drake has outlined and more, then it goes over to the Crown to explain how it already extinguished that right pre-1982. If they can't quite make that, it goes back to the Indigenous claimant to say, well, look, we've proved a right, they didn't extinguish it, so here's the ways in which it is infringing us. And the last word then goes back to the Crown to justify that infringement unilaterally. So in the end, even meeting all of the barriers that are set in place, the Crown has still retained the ability to unilaterally justify an infringement of an Indigenous right. So that's a massive barrier in terms of structure as well.
I could perhaps build on that as well. So the justification step that Professor Hewitt mentioned is not grounded in the text of Section 35. Nothing in Section 35 points towards the ability of the Crown to justify its infringement, or in other words, its violation of an Aboriginal right. Instead, that was entirely read in by the judiciary. and hence my recommendation to consider not leaving this to the courts to interpret.
Muchas gracias por la respuesta.
Thank you for those replies. There are many questions, actually. There's one for both of you, another one, and it says, if we would like to know more about the Canadian experience. So did Indigenous representatives actually take part in drafting the current Canadian Constitution? Karen?
So I had a plan to include an entire narrative about how Section 35 came to be in our Constitution, and it's one of my favorite stories to tell when I teach. So there was no unified position on the part of Indigenous peoples. So some Indigenous peoples were resigned to advocate for some protection in the Constitution, given that Canada's Constitution was going to be patriated. Many other Indigenous peoples, though, advocated against this, and they saw themselves as not being part of Canada's Confederation. Instead, they saw themselves as being in a nation-to-nation relationship with the British Crown. And so they did not want to be unilaterally incorporated into Canada's Confederation. So there was, in fact, litigation in Britain to this effect brought by Indigenous peoples, arguing that they should not be incorporated unilaterally into Canada's Constitution. So, as Professor Hewitt mentioned, there's no one unified position. There are various positions taken by Indigenous peoples at that time leading up to 1982.
There was actually also something called the Constitutional Express that was actually a train and buses. So planes, trains, automobiles that Indigenous leaders were actually going across the country to be able to engage in discussions with Indigenous people at the community levels in order to be able to bring forward positions. And I say positions plural because, as Professor Drake's pointing out, again, no necessity or a resistance to a unified response. Or a unified voice. So it actually came about in complicated ways, but also through a lot of talking, from kitchen tables over tea to train stations and airports and community centers. I will also say that was only with respect to Section 35, really. The Indigenous people were not engaging writ large on all of the constitutional sections and the sections of the Charter, but we're both, I think, answering with respect to the inclusion of Section 35 in the Constitution.
Muchas gracias por su
Thank
respuesta.
you for that. We have a final question for both of you. Could you explain a bit more about how Canada is considering this right to self-governance that is included in many international arrangements and in Latin American countries as well? Karen, please.
Sure. So I focus just on the Supreme Court's jurisprudence, but the executive branch of government has taken its own action with respect to self-government. So the government of Canada, our federal government, has had a policy on the right of self-government of Aboriginal peoples since the 90s. And this policy affirms that Aboriginal peoples have an inherent right of self-government. That's the opening line of this policy. Unfortunately, though, the policy is not self-activating. And so in that sense, it actually doesn't protect an inherent right. Instead, it only protects the right of self-government once that has been negotiated with the federal government. And the policy sets out three sets of subject matters. The first set of subject matters, the federal government will negotiate a self-government agreement with an Indigenous people on that set of subject matters. The second it will negotiate self-government to some extent, but federal or provincial laws will prevail. The third list of subject matters are not available for negotiating. So they are subject matters where Indigenous peoples are not going to be able to exercise self-government. So this policy has existed since the 90s, but there are only a handful of actual successful self-government agreements that have been negotiated under it.
Not quite on point to the question around self-government, but I will also say that the treaties that have been negotiated with Indigenous peoples, and these are treaties that started in the East Coast and moved westward with respect to settlement over the course of 200 years, from sort of mid 18th century to mid 20th century, and certainly in the province of BC continuing on. Those treaties also are very much about the relationships that Indigenous peoples did not sign off sovereignty or the right to self-determine or self-government. So it's also sourced very much in treaties, but as we've both talked to you about, those treaties are now often interpreted in the Canadian legal system, in spite of them being agreements from nations to nation. And so there's also the modern, or so-called modern treaties that Professor Drake's talking about that are negotiated under the policy that she was referring to, that are also generative of administrative agreements as opposed to true self-determination or self-government, as she's described in the limitations of the policy.
Bueno, muchas gracias por sus respuestas. Muchas
Thank you
gracias
very
también
much for your replies.
por
Thank
sus
you
completas y muy interesantes
for your very
intervenciones.
complete
Damos por finalizada
presentations.
esta primera parte del
So
webinar y continuamos
will
entonces con el
conclude this part of the
desarrollo de
webinar
la
and we'll
mesa
continue
redonda
with the
titulado Los
roundtable
derechos de los pueblos
called
indígenas
the
en la
Rights of
nueva
Indigenous
Constitución de
Peoples in the
Chile.
new Chilean Constitution.
En ella contaremos con la moderación de Jaime
Here
Arellano,
we will have the
director
moderation
ejecutivo
of
de Jsca,
Jaime Arellano, the
con
Executive
la
Director
participación
of
de tres
Jsca,
grandes expositores.
and we have three great speakers.
En primer lugar, Verónica Figueroa Huencho, quien
First,
es profesora
Verónica
asociada
Figueroa
del
Huencho,
Instituto de
Associate
Asuntos
Professor at the
Públicos de la
Institute of
Universidad
Public
de
Affairs
Chile,
at the University of Chile.
administradora pública de
She's
la
a public
Universidad de Chile,
administrator of the University of
PhD in
Chile,
Management
PhD in
Sciences
Management
de
Sciences
Universidad
at the
Ramón Llull,
ESADE,
postdoctorado del Center for
postdoctoral
Latin
fellow
American
at the Center for Latin
Studies de la
American
Universidad de
Studies at
Stanford,
Stanford
siendo su principal
University,
línea de
and her
investigación
main line of research is
lo
the
relacionado con el proceso de formulación e implementación de
process of
políticas
formulation
públicas
and
indígenas
implementation of
en
indigenous
contexto de
public
diversidad,
policies in
donde cuenta con
context of
diferentes
diversity, where she has
publicaciones.
several publications.
Continúa Hugo Rojas, quien es director del
Then
Departamento de
we have
Ciencias del
Hugo
Derecho y
Rojas,
profesor de
director of the
Sociología del
Department of
Derecho
Legal
de la
Sciences and
Universidad Alberto Hurtado,
professor of sociology of
doctor en
law
Sociología por la
from
Universidad
the
de
Universidad
Oxford,
Alberto Hurtado,
máster en Derecho,
as a
Antropología y
master
Sociedad
in
de la
law,
London School of
anthropology and
Economics,
society from the London School of
magíster en Gerencia y
Economics,
Políticas Públicas de la
master in
Universidad
management
Adolfo
and
Ibáñez.
public policy,
Es
Universidad Adolfo
investigador del
Ibáñez.
Instituto
He's
Millenio
a
de
researcher
Investigación sobre
at
Violencia y
the
Democracia
Millennium
e integra el
Institute for
programa de
Research on
investigación
Violence and Democracy and is a
interdisciplinaria
member
y
of
derechos humanos
interdisciplinary
de la
research
Universidad Alberto
program
Hurtado.
on memory and human rights at the Universidad Alberto Hurtado.
También participa Salvador Millaleo, quien es
We will also
abogado,
be
licenciado en Ciencias Jurídicas y
welcoming Salvador
Sociales de la
Millaleo,
Universidad de
lawyer
Chile,
and bachelor in
doctor en
legal and social
Sociología de la
sciences from the
Universidad de
University of
Bielefeld,
Chile, PhD
Alemania.
in sociology
Desde
from
el
the University of
2011 es profesor
Bielefeld,
de la Facultad
Germany.
de Derecho de la
And
Universidad
since
de Chile.
2011, he's been a
Fue
professor at the
director
Law
del
School of the
Programa de
University
Derechos
of
Indígenas
Chile.
de la
He was a
Fundación Chile
director
en
of
Chile,
Indigenous Rights
coordinador del
Program
Programa
of
Indígena del
Fundación
Instituto
Chile
Igualdad y actualmente es
21,
consejero
coordinator of the
del
Indigenous
Instituto
Program
Nacional de
of
Derechos
Instituto
Humanos en
Igualdad and is currently counselor of the National Institute of Human Rights in Chile.
Jaime, por favor, tiene la palabra para comenzar con la moderación.
Jaime has the floor. Thank you, Pablo. I'd like to welcome Hugo Rojas, Salvador Millaleo. I don't really see Verónica on the screen unless there's an issue. If someone could let me know whether she has connected, because we thought she could perhaps begin the round table. Well, in the meantime, we can begin our conversation. I'd like to thank Salvador Millaleo, Hugo Rojas, both professors. Salvador and I have had the pleasure of sharing ideas in another seminar some time ago. And Verónica, and with Verónica, we've also participated in debates. As you heard, The presentations of both professors, Jeff Hewitt and Karen Drake, were very interesting. They shared the debate that arose in Canada regarding the recognition of the original peoples and about the limited inclusion in the Constitution and the jurisprudential debates that have taken place. And Jeff mentioned something very interesting that may probably be discussed during the panel. So just to give this a little more movement, Salvador and Hugo, while we wait for Verónica to connect, maybe she's had some technical difficulties. And if so, we will reorganize the conversation. But I would like to ask questions, and then we can go back and forth, and we can pick up your perspectives, your point of view, and generating some sort of debate on the questions. So the first thing we wanted to touch upon here was the acknowledgement of indigenous people in the future constitution of Chile, the one that we will be discussing, we hope, soon as a result of the electoral process we will have this weekend. But it was said in the introduction, in Chile, and this is beautiful on one side, we have over 2 million people that self-determine as belonging to an indigenous people, and that is over 13% of the total population. And the largest community is the Mapuche community, with a larger percent of that percentage, and then Aymara, and subsequently the Aguita. And Chile recognizes 10 indigenous peoples or communities. And this acknowledgement was included as part of a bill for a new constitution that came about during the administration of President Bachelet. And it was as a result of a public consultation held in 2016. But before that, there had been other attempts to define this. In 2004, during the administration of Ricardo Lagos, there was a constitutional recognition of the indigenous peoples by modifying the charter that was in force at the time. So the idea, and what one would expect, is that there be an acknowledgement of indigenous peoples, and that it be debated within the constitutional drafting. In 2020, there was a survey in October with a very interesting universe of respondents made by the Catholic University, where 55% said they wished that the state be declared a multicultural state, and the other percentage wanted it to be a plurinational state. So for you, this would be the question. If we're going to recognize this, how would this happen? And then we can discuss the possibilities and variants. Would you like to begin, Salvador?
Yes, thank you, Jaime. First, I would like to mention that Professor Verónica actually had to urgently care for her mother and take her possibly to the hospital, unfortunately, and absolutely unavoidable. We know that things are very challenging these days, so well, hopefully her mother will do well, and we will be sure to invite her on another occasion. And yes, so on her behalf, she apologizes. So let me get to the heart of the matter. It is true that a survey was conducted, but if you look at the position of the indigenous peoples, and in all of the candidates' platforms, there's actually 90 candidates for 17 spots reserved for the indigenous peoples, and 95% of them actually do not want the multicultural option. So we see that there are symmetries here. There's a lot of noise, particularly when we refer to this broad survey. We see that it does not necessarily agree with the political view of the indigenous peoples. The indigenous peoples, well, they are going to defend this concept of plurinational approach. And this concept has moved quite quickly. It's evolved over time. 10 years ago, this wasn't a concept that was commonly employed politically in Chile, but now it's part of the political discourse. And I think it has evolved and expanded quickly. And it's quite hegemonic as a concept in the indigenous world. This concept of plurination or plurinationality is a summary of what we had in Chile 40 years ago, self-government, with regard to determining our own culture, our own language, territory. Now, that's the concept of plurinationalism, and the tag, if you will, is plurinational. And the demands of indigenous peoples are that these concepts be included in the Constitution, and that actually be what will determine the intercultural relations between the nations. Now, secondly, we can also set up this concept of plurinationality as a key principle in the Constitution from an interpretive perspective. That would be very important now. But what is most important, obviously, is the right to self-government. And that is what distinguishes plurinationalism from multiculturalism. Plurinationalism refers to the collective right, political rights. So as far as the indigenous peoples are concerned, what's at play, what's at stake is having power. Now, this constitution will be useful only if we see that the power is redistributed. It's not about the state providing more economic support for the indigenous people, but rather that's not enough. What the indigenous peoples want is that there's real power distributed to the First Nations. And this involves distributing sovereignty to the indigenous peoples. That's where we need to start and actually bring about a deep transformation of the political concepts so that the indigenous people can be part of the state without being oppressed. And this involves actually transforming the state, changing the state in all of the various aspects with regard to rights and a series of constitutional aspects. So that's where the key is. In this case, the vision will not allow for this multicultural concept, which is something that we referred to back in the 90s. Rather, what will be accepted and what the indigenous peoples are looking for is a state that involves a community of nations and not simply just a tool that can be exploited by one single group within society. Thank you, Hugo Rojas. I think, how about the same question here? And let's also add the aspects that Salvador mentioned well, not what Salvador mentioned, but this concept that is there as part of this debate with regard to not multicultural aspects, but what we refer to as plurinationalism, plurinational aspects. That's key. But we know that, as Salvador mentioned, it's about power, and this debate over power, it brings us to the constitutional debate. It's a very hard, tough political debate. Let me go back to another debate, which is prior to this, which is related to what Jeff Hewitt just mentioned. That is this constitutional narrative in terms of how we are seen, how we want to be seen, how we are viewed, and how we view ourselves, and how the Constitution views us, who we are, etc. So there is an interesting debate here, Hugo, this debate of multiculturalism versus plurinationalism, but the political debate also that will occur, not just with regard to that type of distribution, power distribution, or territorial distribution, regional distribution, etc. This obviously will be part of this new constitutional architecture or structure. So, Hugo, the floor is yours. Thank you for that. First of all, I would like to say that I hope that Veronica's mother's health is not that she's not facing a grave situation. I hope it's something simpler. So first of all, that, and thank you for inviting me. I am here as a simple citizen and a professor. I just do, just so you all know, I do not represent any social group or institution. For your information, that's my caveat, just starting out, my disclaimer rather. And your question is quite provocative, Jaime. Now, allow me to take a stab at it. Let me provide a different perspective. I'd like for you to also discuss this perspective after us. Now, let me provide you with some brief comments before I get to my point. Now, as far as constitutional recognition of the indigenous peoples is concerned, this is something that has been demanded and claimed for quite a while, for 30 years now, at several different times. If we go to the Nueva Imperial Agreement, forged by the former President Alduin on behalf of the indigenous peoples. Now, or there's also what President Alduin did with the Special Indigenous Peoples Commission, where there was a significant, strong clash between the members of the Special Indigenous Commission, who were saying that the nation state was a straitjacket for the indigenous peoples. And even back then, that was back in the early 90s, we saw that there was this new approach, this new look at the relationship between the state and the indigenous peoples. You'll recall the historic treatment of the indigenous peoples under the Lagos administration, or all the various citizen town halls or lobbies with regard to these matters, dating all the way back to January 1991. Everything has either been rejected or simply filed. And basically, these have not been accepted or approved because there has not been enough quorum in the Congress to actually move forward with a constitutional reform in this realm. Now, back in 1991, in fact, a bill was submitted to the Congress, and the goal was to ratify the ILO Convention 169. And in fact, 17 years had to go by before that was actually adopted by the state. And something, unfortunately, similar is occurring today with regard to the constitutional recognition of indigenous peoples. It's been 30 years, and it's absolutely possible this time that the discussions held within the Constitutional Convention allow for indigenous rights to be enshrined in the Constitution. There's a real possibility today that will actually occur. Now, just a few comments that I would like to share with you. 20 years ago, I published a book called the beginning, the dawn of multiculturalism. That was way back when we started talking about multiculturalism. There was no talk of plurinationalism, although I had a conversation with Rolf Ferstes from the School of Anthropology in the University of Chile. He started to use those terms back then. But in that book, I try to provide the grounds that would allow us to turn our nation state into a multicultural state. That was the premise of that book, and that was published 20 years ago. 10 years ago, Gonzalo Aguilar, Sandra Lafos, and Rebecca Stewart and I published another book called Constitutional Justice and Models of Recognizing Indigenous Peoples, obviously in Spanish. The book was titled in Spanish. And in that book, we actually presented a series of options available to constitutionally recognize Indigenous peoples, bearing in mind the progress that had been made in comparative constitutional law. Now, those two pieces of literature, although dated, continue to be legitimate and valid. Now, I do not want to celebrate in advance, but I get the feeling that there are fewer and fewer individuals who are opposed to this constitutional recognition, although there still are some pockets of society who are opposed to this change. There are groups in our society who do not want the Indigenous peoples to be recognized under this Charter of Fundamental Rights. Now, we know that this issue will be a topic of discussion, and I think it's fabulous that this be democratically discussed and decided. I think it's very healthy, in fact. And obviously, we will need to listen to the representatives of the Indigenous peoples, to the activists, to the experts, to the stakeholders, interested parties, etc. And I think it would be an incredible progress if our Constitution would be plurinational, multicultural, pluricultural, and that we could actually discuss whether the Indigenous peoples are part of the Chilean state or whether several nations exist within one nation. I think that's a debate that we need to resolve democratically. Constitutionalism, Latin American constitutionalism, if we conduct a panoramic view of Latin America, I would have to say that they're not uniform with regard to the terminology that they employ when they refer to these groups. Sometimes they refer to nations, indigenous peoples, or ethnic groups, peasant farmers, or different terms, in fact, that have been employed in the Latin American constitutionalism. So instead of just being a semantics issue, semantics are important, of course, but this notion that is employed does have legal repercussions because in international law that will shape, international law defines different categories, different statutes for these groups. It's not the same to say peoples as it is to say minorities. Now, as a citizen who's just here to help out, allow me to make a recommendation. Our Constitution could simply state that the Chilean state is multicultural and plurinational. That's not a dichotomy, right? I think we could actually include both concepts in the Constitution. Now, let's just look at one demographic figure. Out of the 18 million inhabitants in Chile, we know, according to the latest census that was actually repeated, but the most recent census states that more than 2 million individuals claim to be a member of an indigenous group, 2.2, and it is estimated that at least 1.5 million individuals are immigrants. In other words, we are a very diverse society, but we have not recognized that. And many different cultures coexist in this society, and therefore we must also ask ourselves, okay, do different nations coexist? Thank you for that. Let me give the floor to Salvador. You were talking about something that I mentioned early on, And I was referring, you referred to this debate of the power, distribution of power. And when you referred to that, I said right away that during this discussion relative to multiculturalism or plurinationalism, or wherever the road will take us, it was mentioned that we have to predate that. We have to go back to this master narrative, correct? The from the ground up, from the fundamental narrative of a constitution, so that we actually understand who lives here. And in order to do so, you should be able to read the Constitution, and the Constitution should describe who we are, who are the individuals governed by this body of law. And so I think that is something that's going to have to be quickly resolved in this process, because for the first time ever, and I think it was, we're going to be exposed to these very difficult questions. Who are we? Who are we? And you, Salvador, said, well, we are members of many nations. So what do you think about that debate? How viable do you think that discussion will actually occur as part of this constitutional convention process? Do you think it's possible? Do you think it'll be all or nothing? Do you think that there are different perspectives or postures, as we saw in Canada with regard to the 82 Constitution, or do you think there's a more uniform perspective? Do you think the Indigenous peoples are more coordinated and organized? What do you think about that? The most recent perspectives, and also that brings me back to that survey. 50% of the people surveyed are in favor of multiculturalism, and only 17% are in favor of plurinationalism. Now, when we ask the other people involved in this, those are members of the other nations, we see that the situation and the perspective is entirely different.
Well, first of all, in any political debate and in the constitutional debate, there's many basic things, the concept of who we are and the community that we belong to. We need to solve these and intertwine. There's other strategic things that have to do with the correlation of force, and we don't know what that's going to be. We will know on Sunday. And of course, this is an evolving process. You know when the constitutional processes begin, but you don't really know when they will end and how they will end. So this will evolve. And the indigenous people, like any other group, will need to behave collectively or strategically. And we have the 2/3 law that has this clean slate counterpart or weight, and it requires very fine strategic actions. And of course, we need to use a solid discourse, and that will help generate partnerships. And they will allow all the original peoples to go from 17 to that 1/3, and we'll have to negotiate in exchange for other concessions that the others may be interested in. And there's the machinery of power is what the indigenous peoples would like, not so much perhaps the symbolic aspect of power that's important, but it will be filled with content of the participation and the machinery of power. So in this sense, the content of plurinationality is what's decisive, self-determination. And it is not that relevant if we decide that the country is pluricultural, but you have self-determination and self-governance included. And that to me is acceptable if there is no declaration stating that the Chilean nation is one and indivisible. If that is not accepted and it's left open, which could evolve in the future, it would establish the self-determination and self-government in, well, for now, that would be a great beginning to reconfigure these relationships. That would be the strategy. But if we look at it from the perspective of the grounds that this will be based on, it has to do on nature, how power has grown and has been constructed in Chilean politics, and it is centralist, Eurocentric, racist, patriarchal, and it is part of the essence of how the state was built, this denial of original or previous peoples, and therefore this demand for nationality calls on the nucleus of this centralist power that always benefits not even the people of Chile, but the political and economic elites. And so a constitution that could have a different view. It is the first time we will have a constitution that will be the result of democracy, not of a coup, not factically determined. We will finally talk about all this, and it is an opportunity to radically question the way in which this power, the central power, has Eurocentric and racist, patriarchal system has been defined and has denied the existence itself of indigenous peoples. So it also allows us to establish solidarity with the rest of the social movements, feminism, regionalism, the ecologists, and many other groups that question the social and political order of this 1980 constitution. So there will be many voices that will arise to question this, but at the time, when the time comes to structure their participation, there will be a preference to work with the institutions and rights. The institutions means we need to have autonomous regimes. Without autonomous regimes, this constitution will be useless. They might as well stick it in a pocket or in a drawer, but it will be completely useless to reconfigure relationships between original peoples and to reduce conflict. Autonomy or self-government is of the utmost importance. And there's other elements related to the limitation or restriction of economic powers of territories to strengthen the rights, environmental rights. I don't think it'll be possible, but also to prefer rights to the environment. And this is conceived as the right to live in a healthy environment, the right to restore the natural balance, the natural cycles. So there's a series of elements that will determine the political view of indigenous peoples. So it will begin with a theoretical proposal, but then you have to play with the strategic negotiation, and that is where we will include the vision of indigenous peoples and the political machinery. Okay, so I think we've gone into the political realm. Well, we'll go back to other aspects as well. Somehow they go hand in hand. Well, I believe the content is very important, and the key discussion is the recognition of a collective right to self-determination of the indigenous peoples in order to guarantee self-government, the possibility to manage their own resources, the guarantee of self-determination, which is at the heart of the indigenous people's fight. And it's a series of prerequisites for the enjoyment of the other collective rights, like the right to earth, cultural rights, linguistic rights, etc. I would just like to mention the UN Declaration on the Rights of Indigenous Peoples. It's very clear the indigenous peoples have a right to self-determination. And I believe that that is fundamental, and it needs to be included in our Constitution. I will make a couple of political comments that are important and that they go beyond the negotiations that will take place this weekend. I believe the Chilean state needs to apologize officially and solemnly to their indigenous peoples for over 200 years of exclusion, of denial, of racism, discrimination, of abuse, of policies that have assimilated them, and also to apologize for not having corrected this path years ago. For example, the Australian government apologized to its indigenous peoples in February 2008, and it committed to a new deal. I believe something similar should happen in Chile. I believe that it is very positive that Chilean society is growing this awareness of recognizing indigenous peoples, but it also happens that many people in our society don't know the truth of what has happened in these 200 years of the Republic. I believe the Chilean state should create a commission for this. In 2008, Canada created the Commission on Truth and Reconciliation, and the result was known 7 years later. And it investigated the idea of forced assimilation of over 100 years, and that operated between 1874 and 1986, if I recall correctly. So over 6,000 testimonials were brought together, and the conclusion was that the state of Canada carried out cultural genocide and destroyed, even worse, destroyed the social practices that allow a group to continue to exist. I believe that this report explains the collective violence and racism and the traumas, intergenerational traumas, and the report also recommends cultural reforms. The Prime Minister of Canada also apologized. I believe that these political measures are extremely necessary in today's Chile. I agree, but on the other hand, one could ask oneself, history, official history doesn't really describe it, but in Chile we have seen many perspectives, and our history, or the one we learned in school, most of us, it's quite biased, and you open your eyes as you dialogue within your family. I'm from Temuco, so I have roots that connect me, but that I have only connected to recently. I don't really have a original people's culture. So if you start looking beyond things, you find what Salvador mentioned, that difference between the general vision of Chileans, of Chilean population, in terms of what to do regarding self-determination, and the vision that we all have, who we are and who makes up this territory. There's a brutal difference there. And there's people like Pedro Aliqueo, who I admire. He's done a very interesting work and investigating the history and tearing down myths and offering new visions. We could continue discussing this, but I believe that cultural freedom and the Chilean justice system, comparing to Canada, Canada has advanced in this recognition of a historical truth There is a request for an apology in the case of Australia and in Canada regarding what happened. But then when the professors shared with us what is included and is found in the Canadian Constitution today, it's actually a very limited declaration. And then in jurisdictional interpretations, it is further limited, as Professor Drake mentioned, the Vanderpeet case and how that case somehow established requirements on these rights and how they could be asserted, and all this within the Canadian judicature, and that this is the judiciary, excuse me, and this is how they recall that more than rights, one should worry about jurisdiction, the competency, the self-determination, because if there is self-determination, if there's competences, there is no need for rights to be recognized in state institutions. Correlated to original peoples.
Now, in Chile, we have our constitution that governs us with all of its various limitations. And we actually were able to reform the criminal justice system. And as part of that process, for example, the public criminal ombudsman's office developed a specialized area to defend Indigenous people's rights. So that's one issue. And there are other issues that are obviously related to Law 19163 and ILO Convention 169 and its enforcement in 2008, that actually challenged the justice systems with regard to the Indigenous people's rights. And then when we look at what's been carried out to actually forge this cultural identity in terms of justice or to have specialized programs for defending rights, all that is fine and dandy, but how can we actually assess the system in terms of the right or the duty of the state to recognize the rights of Indigenous peoples, specifically with regard to how national legislation is applied, and secondly, if that can actually solve the problem related to applying Indigenous law. Salvador, perhaps you would like to refer to that. I would like to refer to this, but link it to the previous aspects because it seems as though we have dug up this same age-old debate between, well, there's this broader vision of recognition that we all should have, right? That there should be a redistribution of power and at the same time, recognition and reparation, material and symbolic. Symbolic could be asking for forgiveness, but including power redistribution. In Chile, we have had interesting experiences with asking for forgiveness. When Huencho asked for forgiveness, he was kicked out, and 2 years later, in June and September 2017, there was a hurricane, the infamous hurricane operation was deployed, and well, that was a wonderful ending to asking for forgiveness. So it's not just about forgiveness, symbolic, we need a power redistribution as well. And in that regard, with regarding rights, I think that's crucial. It's a crucial issue, and I think the Indigenous peoples agenda is not always fully aware of that. This concept of judicial pluralism and how that can be structured. We know that rights are all about the structure that allows for them. And if you do not recognize the actual Indigenous people's own structure in terms of regulatory space and opportunity, their rights will be reduced to what the state wants to recognize, and they will not be able to recreate their own identity or their own regulations or behavioral rules. And these obviously are crucial because they are the ways in which people's relations are governed, and what the way society is ruled. And we know that the indigenous peoples' relations are much more harmonious with nature. So it's interesting. I would have to say a great percentage of our opportunity to preserve lives and nature and our human relationship with nature really involves providing judicial power, indigenous judicial power, their own power, and not just through indigenous law, but it needs to start from within the state courts. And everywhere we have Convention 169 in existence, this involves the state accepting the indigenous common law concept, but it's been limited, fragmented, often distorted, and the states try to reduce it to its least possible expression. And as a result, indigenous rights, indigenous law are basically museum pieces, except for very certain specific examples where it does have an impact. And now that's the situation. So requesting indigenous jurisdiction, I think, would be a more appropriate way to actually recognize the indigenous people's own right. And when I say own right or own law, rather, once that is set up, when you accept and recognize their own common law, it moves on to a written law stage. And this allows for creating codes and justification and grounds. In Colombia, for example, they have that, and you can study indigenous common law text, and it moves forward, and it's much more rationalized, or rather justified, I guess. And so we need to set up jurisdictions with real power, and that real power obviously will involve taking some power from the existing powers, the powers that be. So indigenous jurisdiction does not just exist for conflicts between indigenous parties. That's what some people think, and that actually is the case sometimes. And or it also applies when there's a conflict between the state and an indigenous party. But there are other examples in the United States. The law is much broader in this regard. With regard to civil law, the indigenous jurisdiction does not just govern indigenous parties, but also private parties who are not indigenous but do business with indigenous parties. So the jurisdiction is expanded. With regard to criminal law, there are some examples of course, this is all based on the various codes, penal codes, civil codes under indigenous law. And for example, if you have an individual committing a crime, a non-indigenous committing a crime, but against indigenous heritage, the indigenous law will apply. There are other examples. In Ecuador, for example, if you have several co-authors or non-indigenous in perpetrators, they can, and they're having an impact or committing a crime against something or someone indigenous, they can all be tried under indigenous law. Anyhow, so the systems are along these lines, and you see that, or there's a broad recognition of common law, or it's approached from the state's perspective, or they want to be as restrictive as possible to maintain the state's jurisdiction intact. I would say that the trend is that you have to be, the logical trend is that you have to have the broadest judicial realm. Also, I would have to say that indigenous justice is actually more effective at times in terms of reinsertion. Hugo can talk about some examples. We have these restorative principles of indigenous criminal law that tend to be more centered. The indigenous law does not usually apply this concept of redistribution, but rather restoration, or not restitution, but restoration. I think that is an interesting trend. There are many trends, but anyhow, all indigenous justice really needs to have enough budget, a large budget to operate. Minimum, they need to apply to human rights. Indigenous societies can often be patriarchal, so it's important to protect the rights of indigenous women and children when inserted in a patriarchal society. And there always needs to be we always need to know that there may be no interest in some little pockets of indigenous society, no interest in having their own jurisdiction. And with regard to certain crimes, the state will always want to secure a certain jurisdiction. Now, you need to be very clear with regard to these jurisdictions so that there's not this tendency to reduce it, to constrict it. In Ecuador, for example, there's a grave accusation with regard to a few cases that actually started arbitrarily reducing or restricting the indigenous jurisdiction.
Very interesting, Salvador, and I will offer the floor to Hugo, because now, we can go back to what has been done by the Chilean justice system to give life to the commitments made by the state to apply indigenous case law, and how it's been addressed by the judiciary, by the prosecutor's office. And when we think about this idea of self-determination or indigenous jurisdiction, it's very interesting. Salvador says, oh, careful, because there's something here that pertains to modern times. Modern times establish some universal rights that we recognize. And correct me if I'm wrong, but I understand, Salvador, that you're saying we have to be careful with some indigenous customs that may be patriarchal or that don't necessarily defend the rights of women and children. And there we understand that the human rights would prevail. And on the other side, we have the crimes of the state that should not be part of indigenous jurisdiction. And how is this integrated? How could the solutions of indigenous justice penetrate the Chilean state system? And how could we work on these different jurisdictions? Well, I believe there's three different and interesting areas to reflect on. One is that we can assess the Chilean state justice system. Another would be indigenous justice. And the third thing would be how you articulate both. How do you bring together the state's justice system and the indigenous justice system? So maybe we can make a few comments and then we can continue on with indigenous justice and how they could be articulated. But if I try to look at the justice system, the state's justice system, if we expect the state justice system to adequately and duly take into account the customs and common law of indigenous peoples and applying the current legislation, the first thing we would need to do is review how state law recognizes indigenous case law. We would need to take a look at the current laws that mention indigenous case law. So I believe that in general terms, and just to further develop the idea, I believe that the Constitution and Chilean law should recognize and further value what has been done in terms of the indigenous law and bring it closer to indigenous customs. Indigenous case law is based on the right to self-determination, which we talked about in answering the first question, and it is closely related to the cultural identity of indigenous peoples. If we look at international law and different constitutions, we will see that the rights of indigenous peoples are recognized, and it includes the rights of indigenous peoples and enforce them when there's non-compliance. And there's some articles, Article 8 through 10th of ILO 169 mention this. An important challenge that was mentioned by Salvador, which is a key concept that we must further discuss, is this idea of legal pluralism, this coexistence of two or more legal systems within one same territory. This has been denied until today. And I believe we should have that conversation because we need to set mechanisms that will resolve possible normative concepts. For example, the right created by the state and the indigenous case law. These are acts where both indigenous and non-indigenous people have participated. In Latin America, if you look at the constitutions of the region, you will see that they are advancing towards a legal pluralism, and some countries have even ceased to consider state law as the only source of law, and they have advanced towards greater acceptance of normative expressions that are compulsory as well as indigenous case law. Let's consider the Bolivian constitution. They have rights. Indigenous people have rights, and even above others found in the international community for the exercise of their own political, legal, and economic system according to the cosmovision of indigenous peoples. So this generates a framework of legal pluralism and modifies the hierarchy of both legal systems. And another thing, another country that has advanced towards the recognition of indigenous rights is Ecuador, where they will be allowed to have assert their own authority in their territories, which have been recognized. So case law, indigenous case law, is also recognized in Colombia, in Mexico, Paraguay, Peru, Venezuela, and indirectly in Nicaragua. Now, you mentioned limitations, and which limitations do we find in Latin American case law? Well, there are some constitutions that establish that the state constitution has greater hierarchy than indigenous case law, and this is something that we should discuss. Are they at the same hierarchical level or not? And you have the Colombian, Mexican, Paraguayan, Venezuelan constitutions. There's other constitutions that establish something that you already mentioned, which state that indigenous law is subject to the fundamental human rights. And this is the case of Bolivia, Ecuador, Mexico, Peru. So that's all I have and would like to mention for now. And the question would be, how is traditional law addressing this? So my first suggestion would be to look at not the states legal system, but what is actually being recognized. And of course, the judges need to abide by the law in force, the current laws in force, and that is where we would find that there are indigenous rights and they exist, but it also has to do with legal, the cultural system and the treatment that the justice operators or judicial operators give to these topics. So we have a partial development and effort of by some programs and some institutions of the Chilean state. And in the second place, the inclusion of ILO's 169 to in Chile, and so that the laws not be conflictive. And we know that in criminal law, it is even more important.
Now, Hugo, you were talking about an issue that we should refer to and then close the conversation. And you were referring to something more powerful. Now, Professor Drake really surprised me. I had this concept of what had occurred with regard to Indigenous law and with the First Nations in Canada. And thank God that we are debunking myths. I thought more had been achieved than what she and Professor Hewitt have told us. Now, she said that Section 35 of the Canadian Constitution does not even actually reach a level of reconciliation. And it doesn't even reach reconciliation. It doesn't even refer to that level, she said. And so the question is, well, here, do you think we can possibly make progress and move toward this coexistence, as mentioned by Salvador, or maybe you said this, Hugo, but do you think that if we can make progress with regard to self-determination, do you think we could actually then have indigenous jurisdiction and that this would be able to coexist with the traditional system? And we know that justice and substantive regulations will govern certain aspects within the territory. And as part of this constitutional solution, what does this actually mean with regard to this constitutional solution? I'm just throwing that out there. Now, is it possible? Do you think there will be a coordination or integration of both systems? And if there's integration, it would mean that the traditional state judicial system would absorb the indigenous jurisdiction, or do you think there will be a peaceful coexistence where we have two systems that are mutually recognized at certain levels in terms of equal hierarchy and equality in terms of justice? Who would like to answer this?
Bueno, si quieres, voy yo, Salvador.
Sí, dale.
Bueno, yo apoyo la tesis de la
I
convivencia.
would like to support this thesis of coexistence for several reasons. First of all, that would occur if you recognize the constitutionally recognized plurinationalism or multiculturalism as a society. If we say we are a diverse society, then that will contribute to channeling these demands and the requests for plurality on the one hand, but this will also help us ensure that there is a coexistence of the different we have to strike a balance between this concept of plurinationalism and political jurisdictions that are different. So we need to strike this balance between legal judicial pluralism and the integration of a different state within the traditional state. I think that is very challenging because throughout our history as a nation, as a country, Unfortunately, there have these very powerful mechanisms that have dominated certain areas by use of force, discrimination, coercion, etc. If we quickly look back on our history, we can see that the European social economic concepts have actually influenced significantly the legal system, and that has resulted in excluding the indigenous peoples and depriving them of their land and their culture. So the heart of the matter is actually all about dignity. All individuals want to be recognized and appreciated and valued by others. The same occurs with nations and peoples. It's important to have the indigenous institutional authorities recognized and recognize their regulatory systems, recognize their indigenous justice system. That's all part of this concept of recognition. And when indigenous justice refuse to accept this false recognition, and when people in our society are completely indifferent to the indigenous people's demands and claims, this also has an impact on their dignity. Those of us who have been indifferent all these years also need to accept a certain amount of responsibility for the situation that we are currently facing today, because that indifference has actually made it possible to postpone this this long desired recognition. Now, if we recognize the legal judicial pluralism that exists in Chile, if we do not recognize this under the Constitution, then it would make no sense to have indigenous jurisdiction because it would still be subject to the ordinary traditional justice. But if I recognize the judicial pluralism, I will have to recognize different jurisdictions within the territory, the Chilean territory. And some of these actually may be the indigenous common law systems. If the indigenous common law sets up its own justice system to resolve certain controversies that are of interest to the indigenous peoples, then the indigenous justice will be a key element that we will have to publicly discuss. And I truly appreciate this seminar because we need to talk about these issues, but with more stakeholders and with more importance and relevance and urgency in Chile. I think we also need to agree under what circumstances will state jurisdictions apply to organized crime or what have you, for example. But we also need to reach an agreement with regard to what cases will be governed by indigenous justice, and what will you do if there's conflict between both judicial systems? For example, if there's a conflict between both, which one should have priority, which one will take precedence. And so this obviously brings us to discussing the jurisdiction, the purview of these systems. We need to make this very clear that which system will apply in the event of a conflict. But also, we have to determine the mechanisms to resolve conflicts of jurisdiction. And then the other debate is related to who is going to be constitutionally resolving whether or not we involve, who will constitutionally resolve conflicts between both systems. How can you solve these issues, or how can we design that mechanism that will allow us to constitutionally interpret? Salvador, what do you have to say about this?
De partida, es difícil imaginarse un país donde coexista una justicia.
A country where you have indigenous and state justice coexisting? Well, that would be something that the Constitutional Convention would have to resolve. Well, somebody needs to resolve the constitutional interpretation aspect, and who would do that specifically with regard to what we're talking about today? Because this is not the traditional constitutional debate within a traditional system. Excuse me for being redundant, but rather this would be a discussion that would involve traditional state versus indigenous jurisdictions or rights. Well, it's important to understand that we need to reimagine, revisit the structural, the judicial structures. We can't start from scratch and say, okay, indigenous jurisdiction, but the way in which indigenous rights have been treated by the state institutions has been extremely deficient. And that's why we are severely questioning the lack of protection of indigenous rights. For example, there's the original sin that the National Prosecutor's Office is being charged with, that it's trying to convince the more conservative groups that it will control what's going on. And today we see that they're painting what's going on in the Araucanía as a crime. We know that there's certain radical groups are acting and attacking, and the state is processing them a certain way through criminal justice and criminally prosecuting them, and then the prosecutor's office takes its role there. So there's this perception of the indigenous peoples and communities that the National Prosecutor's Office is against them.
It was devised to prosecute and repress them, and there is an imbalance with the Public Defender's Office, which began at an early stage. It began the Mapuche Defender's Office, but the Public Defender's Office has an imbalance with the Prosecutor's Office, given that its autonomy does not is not recognized by the Office of the Public Prosecutor. So it's a lack of consideration for case law, which makes it necessary to have indigenous justice, because in this model of conviviality, there needs to be dialogue about justice, and this dialogue will allow the state cases to take into account the characteristics of the defendants, and any conflicts that have an indigenous component will be treated differently. And everything that is that comes out of that doctrine or jurisprudence will help the state's judicial system to incorporate the indigenous case law. And we can recall the cases of family courts. There was a deaf conversation or dialogue where there was some sort of composition, but it was mediated by the state when indigenous customs operate in a different manner. So it generates an artificial conflict that didn't exist between the demands of protection of indigenous women, and basically again, it was a deaf dialogue. They were interpreting differently or at their own will to create the possibility of restoration or compensation agreements. So these show us that case law has not been well received by state judicial systems, and that's why it's important to have indigenous justice system in order to apply indigenous law or to the extent necessary. And this means that there should be instances where this could be unified, where in all this diversity, where there could be unity based on principles which basically is what human rights provide. Human rights will be the common framework where these jurisdictions will have to talk amongst themselves. The Colombian system has this minimum in terms of some rights. There's a proposal they make to establish that there's certain things that the indigenous justice system could not pass or could not interpret their own way. So it needs to be there in the substantive manner, but also in terms of competences. And this leads us to innovations made by Bolivia. Bolivia has a constitutional court that resolves these issues, but it was modified for this. It's a plurinational constitutional court. It is formed by legal experts from original peoples. But if we eliminate it, I am increasingly in favor of eliminating the constitutional court finally, once and for all, and then all the control in the Supreme Court, it will lie in the Supreme Court. What will they do? Will they have judges in a room especially for the indigenous people, or maybe they will have to work better? Because I'm thinking about our current processes. A court of appeals could be different if we had an annulment. It would make sense to have a technical debate, but these court ministers need to be properly trained. So there are needs in terms of training and the certification of judges in one or the other system, so that they be informed of due process and adjusted, of course, to each jurisdiction, and that can be resolved in a debate, because there may be a scenario of, say, that could be resolved by the Supreme Court. And it is not an indigenous problem regarding an indigenous. It is two groups debating procedural or substantive law, and these require, of course, to be reviewed by a higher court. Well, that's very important, because we need training in the Judiciary Academy. There needs to be proper training. There's some courses, but they're very general, very theoretical, and they don't specifically talk about indigenous rights, but there needs to be trainers. When we go to Canada, when you visit Canada, you will see that each province needs to have a department, a division for indigenous studies. There needs to be experts in each university in law schools in Canada. So they have a legal culture that is different from the onset, from universities. But you have also participated in training at the university. How do you see this? I have to say that these topics that we're talking about now are very audacious. They're very bold and new in our country. I wouldn't like for us to have the feeling that the ideas we've expressed this hour are shared by our peers. Recognizing indigenous justice, and you know this better than us, you were once Undersecretary of Justice, implies a significant reform, not only in our judicial framework, but also in our judicial culture. Recognize them. If we were to recognize an indigenous justice system, that would be a starting point. And once it is recognized, we would have to learn from many other compared examples. Canada, Australia, New Zealand, Colombia. We will have a very important challenge. It may take decades. And we will also need to be attentive to the evolution that may take place, practical problems, coordination mechanisms, opportunities for improvement. And we believe that this is important to expand it also to the Ministry of Justice. They will be of the essence. And between these two justice systems that need to be addressed with special perspective and make a diachronous perspective. And of course, the indigenous culture course should be compulsory in all law schools. And if we were to ask how many law schools in our country teach indigenous culture or indigenous justice system, we will see that there are none, or there's very few. And I'm sure we would be quite, we would receive pessimistic responses.
La verdad es que esa decepción nos la
The
llevamos
truth is that this exception is, we find this in many schools, law schools. They have legal clinics that that specialize on this. There's some for family and for labor issues, but many law schools don't have these clinics and they don't have that possibility. So what else can I say? That it's very difficult to include this into the curricula.
Now, we have come to the end of our webinar, and as Hugo mentioned, we are talking about the consequences of the consequences of the consequence of the consequences. There should have been a first debate, which would have been what will the status of the indigenous peoples be in the new Chilean constitution? And from that, use that as a sounding board for discussing the other consequences. And recognizing indigenous jurisdiction involves a first stage of recognition and the right to self-determination. And it's likely that at some point, well, after that, you would move into coexistence of both systems. And what does that really mean? Well, Hugo said that we need to be cautious, be careful, because this means a lot. In Salvador agreed, he nodded in agreement. One thing is to pass a reform and then to deal with the consequences and all the various errors and mistakes made along the way. So this effort, there's a great deal of learning and a learning curve, obviously. So that was the purpose of today's discussion, to open a can of worms, I guess, if you will, with regard to the rights of individuals and the rights to justice. And this was on the eve of this election. We're changing history, and we want issues of justice and conflict resolution systems and the rights related therein be issues subject to debate and that are discussed. And that's why we wanted to foster and rely on this partnership with the government of Canada to bring into this discussion 3 key speakers from the School of Law of Osgoode and one of our council persons to discuss what has occurred in Canada with regard to rights, the indigenous people's rights and self-determination or not, and with the indigenous law within the Canadian system, and then with Salvador and Hugo and another colleague who was unable to join us tonight, given her mother's sickness. We were here to discuss what we can do in Chile and what we should be considering, or the issues that we should start teasing out under this constitutional convention concept. So there's a lot more to discuss. In the end, it is an issue of power, I would have to say. There's no doubt about that. But I would always like to, I'd like to think that this constitutional debate is a narrative, as Jeff Hewitt says, a narrative as to how we would like to see ourselves, how we want the rest to see us, how we want to understand others, and how we want to all fit into one territory. And we need to be able to look in the mirror and not take individual selfies, but look at each other as a community, as community members. And that's probably where we will mark the difference between individual rights, the liberal individual rights, and the collective rights, and the community rights. Several communities that also hopefully will become the community that we can have several various interrelated communities that are part of this territory. And that's the part of this constitutional debate. And hopefully there will be decisions made in that regard. There has been progress. We have had setbacks, and we have realized that what we have done thus far is not sufficient to resolve issues that, as mentioned by Hugo and Salvador, have been dragging on for decades, and we've tried to resolve these issues for decades. And so it's time for us to make some progress with regard to recognizing the indigenous peoples. We know this has been very difficult for that to occur and to include their common law justice into the system, and setting up mechanisms for coexistence. That's all part of the challenge. And Jsca has wanted to be part of this first discussion and to hold a webinar on constitutional issues in Chile with regard to the rights of individuals, indigenous individuals, and do this with Global Affairs Canada. Thank you for that. I would like to bid you farewell, thanking Salvador Villaleos, Hugo Rojas, and hopefully Veronica's mother is doing well. I would also like to thank the Canadian ambassador in Chile, the members of our executive committee, our directors or counselors from Canada, Professors Drake and Hewitt, and also like to thank our Director of Studies and Mr. Gonzalez, who is behind the organization of this webinar, and Pablo as well for having been our Master of Ceremonies, and Sandra Araneda and Jose in charge of the streaming, and our interpreters who have also made it possible for the English-speaking professors to speak to the Spanish-speaking audience, and hopefully the English speakers are understanding what we're saying in Chilean Spanish. Thank you very much to all of you, ladies and gentlemen, and thank you for joining us here tonight. Thank you for the invitation. That was this